Good afternoon, or evening as the case may be. Thank you so much for visiting the website of Stephen Danz Associates. I am Steve Danz. Naveed Kanani, a co-counsel and associate, is with me here today to discuss a number of issues having to do with Los Angeles employment law. Coincidentally, Brentwood in Los Angeles is the firm statewide headquarters. Very honored to have Naveed and his team of Melina and Veronica working in the Woodland Hills, the San Fernando Valley, although Naveed has covered the entire state and just got through with a whole bunch of great settlements up in the Santa Cruz area, I believe, Santa Clara. So we appreciate all that. And what we're going to do today is just talk a little bit about a team approach to law. Naveed is then going to talk about the areas of law in which we practice. Come back to me, we'll talk about the different approaches that one can take to settling a case and what you should probably be aware of right now as long as you've come this far to watch the video. So with a team approach, we think while there are a lot of good law firms out there, our firm is a little bit different in that we co-counsel with some of the leading practitioners throughout the state. We have some on staff, some are co-counsel, and the point of it is to make sure that you have complete representation at all times, the financial resources to do the litigation necessary to advance your case, and the expertise in a particular area. And Naveed certainly brings a lot of that to our Valley and Los Angeles team. So Naveed, why don't you discuss a little bit about some of the areas of law in which we practice?
Sure, thank you. So the general areas of law that we practice include the California Government Code as well as the California Labor Code. Under the Government Code, you deal specifically with things like discrimination, harassment, and then transferring over to the Labor Code is more issues related to not being paid properly or not being given your breaks. A very interesting area of law that kind of has sprung up, I think, over the last couple of years that we've been handling a lot of is the issue of severances. What do they say? What do they mean? Can they be negotiated? What are the terms that need to be included in an effort to protect you and your claims or protect you in general? And Steve and I have found that we have a great success in negotiating those and including terms that protect our clients. That includes, again, related to if you do have a claim or not. If you are being provided a severance agreement, it's very important that you do reach out to us so that we can at least give it a look to see what can be changed, what can be included, and if anything can be negotiated.
Great, and thank you so much for that. Multiple approaches, ladies and gentlemen, really refer to the various arrows in our legal quiver that any good employment lawyer would bring to your fight. We would obviously, as Naveed said, try to negotiate a settlement. That is very common in settlement agreements or severance agreements, which can have tax advantages properly reworded. So we do a lot of severance agreements. The other approach is to have a mediation. Another approach where a third party basically sits and acts as the first independent trier of fact on the facts of your case. Another way is to go through administrative agencies. That's not as popular these days because state and federal government administrative agencies only take a very few cases, and it can be many years of delay. So we like to basically, where appropriate, close out the file, get you your right to sue letter, and move forward with either a class action, generally under the Labor Code, or a right to sue letter from the Department of Fair Employment and Housing for your discrimination rights based on, what are the usual categories?
Age, race, military status, disability, sexual preference, and I think it's about 12 or 13 other categories.
Excellent. And so if we have to file, we are not afraid to file. I think our firm has a reputation as being a law firm that will file, and we do not make idle threats. So if necessary, we will file the case in court for you. All of our cases are taken on a contingency, which means basically you do not pay by the hour. And then as far as what you should do now, review your timeline, make sure that you know exactly when each adverse job action happened. So when you call us, we can determine whether or not it appears that there are any time limits that still must be protected immediately. Naveed, what would be some of the more critical time periods in your experience?
At a bare minimum, you want to keep an eye on the 1-year timeline from the last action of whether it's discrimination, harassment, failure to pay a wage, or if we call in legalese retaliation. So when an employer takes an adverse action against you for you reporting either some kind of concern or a disability or something like that. The 1-year mark, I think, is the absolute necessity. Some statutes and some different legal quivers that we talk about here have 2-year or 3-year statutes, but you always want to keep an eye on that. You do contact us or an attorney within the 1-year mark so that we can evaluate it and determine if that's the actual statute or if there's some greater one or longer one.
And a shorter one. For example, public employees, if you work for a governmental agency, we just had a claim from an employee in a water resources agency. They only had 6 months to file what's called a tort claim. And so we have to be careful that we've observed the 6-month, or it could be extended to 1 year, but some of those public employment statutes are very short, and even shorter are union cases. Now, generally, unless it's discrimination under the government code, union employees are forced to go and do their own negotiating with the union to get representation, and there can be as short as a 10-day window period to file a grievance with your union. So as we conclude, please act now to advise us or your chosen attorney of your timelines. Thank you so much.
Thank you.